Hello, and thank you for joining this webinar. My name is Ellis Lake, and I work in the specialist legal team here at Larkin Gowan. Today, I'm going to give you an update on the SRA Accounts Rules. Just to summarise what I'm going to cover here today, we're going to cover some updates in the SRA's guidance that run alongside the rules, systems and controls, and the role of the COFA in keeping client money safe. And lastly, we will just touch on the expectations of the SRA when operating during COVID-19. So in terms of the SRA guidance, we now have rules that are far less prescriptive than the 2011 rules, which contained lots of meaty detail and were extremely specific. Instead, we have now just got 13 rules. However, although much of the detail has been stripped out, the overarching principle of the rules remains the same, and that is to keep client money safe. However, as so much of the detail has been removed, there are areas that are unclear, and this has sparked a number of questions from law firms. As a result of that, the SRA have issued additional guidance and also updated various pieces of existing guidance, which can be found at the link contained within the slides. I would recommend that everybody goes through and reads the guidance, as this really does need to be considered alongside the rules. The rules themselves aren't enough anymore. It shouldn't be forgotten, though, that the rules do provide a level of flexibility to law firms. It's down to law firms to review their systems and controls to make sure that these rules now at best apply to them, their work and their clients. It doesn't have to be a one-size-fits-all approach anymore, and the SRA recognises that. So, for example, timeframes that used to be very, very strict in the previous rules can now perhaps differ from firm to firm. And that would be based on perhaps the size of the firm, the nature of the work that's undertaken, the location of the firm, and the type of clients that that firm has. I don't plan on going through all of the guidance today, as there is a lot to go through. Instead, I'm just going to focus on 4 key areas. As reporting accountants, these areas we see coming up time and time again, and they often are misunderstood by our clients. So the areas are taking money for firms' costs, clients' own bank reconciliations, banking facilities, residual client balances, and donation of those to charity. It's just moving on to taking money for firms' costs. This rule this is captured in Rule 4.3a, and that rule says you must give a bill of costs or other written notification of costs incurred to the client or the paying party, and that's before you can transfer any money from the client account to the office account for costs. When we say costs here, we're talking about fees and any disbursements. So in comparison, in the 2011 rules, you didn't have to send a bill to transfer money to settle any disbursements that had been paid. So people are then asking, okay, so do I need to send a bill for disbursements alone before I can transfer any client money? The answer to that question is probably not. If a firm has paid a disbursement on behalf of a client and it was properly due, then you can take the money from client account if the client is aware that that type of disbursement is going to be incurred and the likely value of that disbursement. This is something to consider putting in client care letters or your terms of engagement, and a good example would perhaps be land registry fees on a conveyancing matter. So if the disbursement has been incurred and the firm has a liability to settle that disbursement, or if it indeed has already been paid, then the money can be transferred. The important word that I've covered a number of times there is incurred. So the issue lies with anticipated disbursements, and can anticipated disbursements be billed and transferred over from client account to office? And here is where there is a significant risk. If a firm is billing for anticipated disbursements and or billing in advance for fees and takes the money across from client account to office account, there may be a large problem. When the money is not in client account, the client's money is not protected, and they need to be aware of that. So some questions to think about if you're billing in advance and taking the money are: what happens if the matter doesn't proceed? For example, somebody pulls out of the transaction. What happens if the relationship breaks down with your client and they want to disinstruct you? What happens if the firm was to go insolvent? Essentially, the SRA do not want firms to be systematically billing in advance for fees and disbursements that aren't incurred yet. So this is all heavily discouraged, particularly if it's only been done for a cash flow advantage. So I would suggest having a look at the SRA's guidance in this area if you are unsure, but ultimately law firms do have an obligation to keep clients' money safe. Moving on next, we come to the client's own account. This is covered in Rule 10 in the new rules and concerns accounts where solicitors are signatory on a bank account that's the client's own personal account. We see this commonly with deputyship work or court of protection work, and they're really high risk, as these clients are usually vulnerable people, and the SRA have recognised that, and that's why they've amped up the rules in this area. So the rules concerning client's own account actually used to be the same as those for joint accounts, which just meant that you had to maintain copies of bank statements and copies of bills. However, the new rules go further and they deem them as client accounts, and therefore they fall under all of the same rules as the main general client accounts held in the firm would. And that means there's a requirement to reconcile them at least once every 5 weeks. As to be expected, there has been some issues in relation to this. The SRA understand that, and that's why there has been some additional guidance released in this area. It's very likely that these accounts won't have separate ledgers built into your law firm's accounts software, so there needs to be consideration around how you are going to reconcile them. There needs to be more than just the bank statement, so there needs to be something else drawn up that acts effectively as the ledger. The SRA have set out some minimum expectations that cover that, and the minimum expectations are that a central register is kept of all the accounts operated. You should be doing this anyway, you should have been doing it before, and it's important that fee earners are communicating with the relevant teams when appointed in these positions, just to make sure that all matters are captured. Firms need to be keeping a separate record of transactions that originate inside the firm, so those undertaken by the solicitor themselves. Here is what I was talking about. You're basically recreating that ledger that you do not have on the system. And you need to demonstrate that you have then reviewed those transactions and understood them, and that they reconcile to the bank statement. The COFA needs to be looking at these at the same time he's looking at the other client account reconciliations. The record of transactions needs to be backed up in the client file as well, so with all the supplementary evidence of any expenditure or receipts that have passed through that client's own personal bank account. It's important for firms to satisfy themselves and document that the client's money is not being used for other purposes. So that's why the SRA deem this area to be very high risk and an important one to be thinking about. Moving on to the third area I was going to cover, we've got banking facilities. This has always been a critical area for the SRA. The position hasn't changed. It's specifically referred to in the new rules, which just states how important they do deem this area to be. There must be a proper connection between the receipt of funds held and the delivery of regulated services by law firms. There is lots and lots of guidance on this topic. And the SRA have also issued a number of case studies which cover various different scenarios. I'm going to go through a few of those case studies now, but there are others on the SRA website to look through. And of course, if you've got any queries, then just by all means get in touch with us. First case study we've got is trust administration work. So if the solicitor is acting as a trustee, then that is fine. I don't think you're going to have too many issues there. But if you are acting for the trustees, and they're asking you to make certain payments which appear purely administrative and not in relation to the work you're undertaking, you need to ask if there is any justification for doing this. Consider why you're being asked to do it and why it cannot be given back to the executors for them to deal with. We all want to be as helpful as possible for our clients, but we need to comply with the regulations at the same time. Recurring clients we see very often. In this instance, if there is excess funds at the end of the matter, we often see clients say, "We're going to engage you again. Please just keep hold of the money and use it against the next matter." Our advice is you can't do this, and you need to be saying no to your clients. They can just pay the money back in when the next matter starts up and they've engaged you to do that. Then we've got rent deposits. If it is a residential rent deposit, there are government schemes that deal with these, so you shouldn't be holding on to those. With commercial rent deposits, the position is less clear. The SRA expect there to be an ongoing legal transaction and delivery of regulated services. If the services ended when the agreement was signed, then the deposit should have been released at that point. However, if you're still providing ongoing work to the client in relation to the deposit specifically, then that is okay to then still hold on to it. So commercial rent deposits, less straightforward. Just because it isn't a residential deposit does not mean you can hold on to it. There does need to be some work ongoing in relation to that deposit specifically. Then got unconnected payments. Clearly, this is wrong and you shouldn't be doing it, and hopefully alarm bells are ringing whenever this is asked, or if it is indeed asked. Any money held by the law firm and payments made by the law firm need to be in relation to the service you're providing, and that's the end of it, really. Lack of availability of banking facilities. For example, you could have a client that is struggling to set up a UK bank account. You cannot hold on to the money for these clients. If there's no other reason than purely for convenience, then you cannot do it, even if you are acting in their best interests. So just in general, we need to be avoiding banking facilities in these scenarios as much as possible. A way of identifying matters where you're potentially offering banking facilities is looking at matters with no movement on them in the past, say, 6 to 12 months. Most systems will allow you to run a report for these, and if you can, what I would do is filter out the interest payments so you can see those matters that are truly dormant. You should be doing this regularly, and the COFA should be reviewing it. Lastly, and just in relation to the SRA guidance, we've got residual balances and donations to charity. Residual balances, we see them rising at the end of the matter, and firms can sometimes struggle to return these. If all efforts have been exhausted and they cannot locate the client, then they look to donate the balance to charity. This is the most common area that arises in qualified reports, and I think a good place to start is to query why these balances are arising in the first place, and is there something that could be put in place to avoid it? So think about better calculations when asking clients for money, getting the client's bank details at the start of the matter, reviewing the ledger cards regularly to make sure there's nothing that you've forgotten about or missed, etc. The issue isn't necessarily residual balances, though, or having residual balances, as there can be good reason in some instances why they sit there. The issue is more about what procedures are in place to deal with them. Can the balances be quantified as well? The serious issues arise when balances are in large numbers and you do not know how they've arisen. The old rules used to go into great detail about how to deal with the balances and how to donate them to charity. This isn't included in the new rules whatsoever. Instead, it's tucked away in the guidance, and the new rules are very, very brief on it. Rule 5 says that client money can be withdrawn in prescribed circumstances or on the SRA's prior written notification. The prescribed circumstances deals with balances under £500, and that is £500 on an individual client matter basis. So the SRA say that you do not need the SRA's authorisation for these balances, so long as reasonable steps have been taken to locate the rightful owner of the money before making the donation to charity. So things to consider there: if emails and phone calls aren't getting the response, perhaps using the Department of Work and Pensions letter forwarding service, searching on social media, Companies House, internet searches, things like that. If those steps are exhausted and you've made at least 2 attempts, the firm can then choose to donate the balance to a charity of its choice. That charity doesn't have to offer an indemnity, so if the owner turns up in the future and is asking where their money is, the balance can be returned or should be returned. But if the charity that you've donated to doesn't offer an indemnity, that cost would have to be fronted by the law firm. And in these scenarios, so balances under £500, you cannot deduct costs involved in locating the owner. The amount has to be the full amount plus any interest that is due to them in accordance with your policies. Then we've got balances over £500, and that's what the SRA's SRA's prior written notification covers, and these require authorisation by the SRA. At an absolute minimum, the SRA asks you to make use of the DWP letter forwarding services and free searches on the internet. So before even going to the SRA for approval, I would suggest that you do those 2 things as a starting point. If you still get nowhere, then the SRA is then going to be getting involved. The guidance in this area goes even further than that, though. It says, if proportionate, you could consider local or national newspaper adverts to try and locate the rightful owner, or even a tracing agent. But here we're talking about very large balances where the costs involved of doing that would be justified. However, the SRA give no further steer on what proportionate means. Third-party costs, so if anything's incurred third-party costs-wise, such as the DWP letter forwarding service, they can be deducted from the balance when paid over to charity, but initially those costs must be paid out of office, just in case authorisation isn't given to pay to charity. So the crux there is there needs to be a plan of action. There needs to be regular reviews of the residual balances. Monthly would be good. There needs to be a plan of action in place to deal with them, which is methodical and deals with all balances. So just cherry picking the easy ones and leaving the really old, horrible ones isn't good enough. They all need to be dealt with. So that deals with the SRA guidance. I'm now going to move on to systems and controls and the COFA's role in keeping client money safe. The SRA expect law firms to identify breaches and correct them promptly. If there's any lost client money, this needs to be replaced immediately, and this is all covered in the rules. Of course, if there are any material breaches, these should be reported to the SRA when discovered. So don't wait for your annual review and you're reporting an accountant to do it for you. You should self-report to the SRA if you believe a breach is material. However, this does pose the question of how firms stay on top of these requirements, and the breaches register, I think, is a good place to start. We often see that breaches registers could contain more detail. Worst case scenarios is that a firm doesn't even have one. It is really important to keep a detailed record of breaches to demonstrate to the SRA that the firm's systems and controls are adequate to comply with the rules. Things we would expect to see on the breach register are listed on the screen, and just running through each of them now. So we've got the date the breach that was occurred, the date it was discovered, and the date it was resolved, the amount that was involved, the rule that was breached. Doesn't matter if you get the wrong rule, but give it a go. Details as to what happened, the the person responsible for the breach, not because they're going to be pulled into a meeting necessarily, but so patterns can be identified, and it can also identify any training needs, things like that. But also, if there are breaches among a large number of people, it suggests that there is a downfall in overall systems that needs to be addressed. Moving on, there should be a column to say whether it's material or non-material, and importantly, why you came to that conclusion, i.e. this breach is non-material as the amount involved was small, it was purely administrative, an administrative error, and it was corrected promptly upon discovery. Reviewing it regularly, the COFA needs to review the breaches register regularly and look for patterns. Think of same breaches, same type of work. Does anything need amending in the system? Is there some training that is needed in a particular team or by a particular person? What has been in place to ensure that that breach doesn't happen again? That's another thing that we would be looking for on the breaches register. And importantly, there needs to be an effective communication line between the COFA and the teams so that they're not scared to report and they know how and what needs to be reported, because there could be things going on that perhaps they don't think is an issue. We can then go further than the breaches register, and I've listed a few things here on the screen that I think the COFA should be looking at regularly. So we've got client account reconciliations, obviously required by the rules to review and sign them at least every 5 weeks, and that includes clients' own accounts operated by fee earners. We've then got regular reviews of the breaches register to look for patterns, like we just touched on, regular reviews of client matter listings, so looking at any suspense accounts, making sure that they're being used for the right purpose, residual balance reviews, like I touched on earlier, any matters with miscellaneous names, as each matter, needs to have its own ledger and be set up in its own right, things like that. The COFA should review the reporting accountant's management letter from the prior year as well, and ensure that any actions that have been raised in that have been or are being dealt with. And all of the above demonstrates that there are effective systems and controls in place and to the SRA and to your reporting accountant. Just remember, your reporting accountant is testing you against your controls, so it is important that you're documenting all of this. And lastly, just before I finish, don't think you can get away without talking about COVID-19. The new rules have probably helped in some way to allow that flexibility with timeframes and working out what the rules mean for you and your clients. But you need to make sure that your decisions are documented and how and why you arrived at those decisions. So if you've got issues with paying in client money, issues with bank reconciliations being completed, things like that, as long as you're documenting what issues you're having and what you're doing to overcome them, that should be fine. Think about updating your procedures manual if we're now working more remotely. Do your systems and controls allow for that, and is that all updated in your manuals? Update any client care letters if you haven't already as well, if necessary, going back to what I said about the disbursement treatment and making sure that they're aware of the typical value of likely disbursements that you're going to incur on their behalf. Coming back to the breaches register, you still need to identify breaches and correct them promptly, and immediately replace any lost client money. That doesn't change even due to COVID, and any material breaches need to be reported to the SRA, like I said before. So it might be less pressing now, especially as we now transition out of lockdown. But if you are experiencing issues directly in relation to COVID, then the SRA don't deem that as a material breach. So that was everything from me today. Thank you for your time and listening to this webinar. Please get in touch with us at Larkin Gowan if we can be of any assistance to you. There is also lots of material on our website which may be of use, so please go and have a look. Thank you.